Good morning and welcome to the Practical Guide to Employment Law's webinar. I'm Sean Lyons, Executive Director of the South Dakota Retailers Association. Today's program will feature a presentation by Chris Hoyme of the employment law firm of Jackson Lewis PC. Jackson Lewis is a nationwide firm which deals with all facets of employment law entirely from a management aspect. Chris is a principal in the firm's Omaha, Nebraska office. He has successfully defended employers in over 40 federal and state courts, as well as before numerous federal and state administrative agencies. He is a member of the South Dakota Bar, and Jackson Lewis has offices in Rapid City. SDRA has a retainer agreement with the Jackson Lewis firm that allows our members to contact the firm at no cost to get answers to general labor law questions. In addition, SDRA members are eligible for discounts on certain Jackson Lewis services, including developing employee handbooks and representation in labor lawsuits and unemployment insurance appeals. For more information, please contact our office. A couple of notes before we start this morning's presentation. The phones of all attendees are muted, so we won't be hearing background noises. We'll have a question and answer period at the conclusion of the presentation. You can ask a question at any time by going to the webinar panel on the side of your screen. You should see a questions box. Just type in your question, click on send. If you don't see the questions panel, you may need to click on the arrow to maximize it. At the conclusion of the presentation, I'll read the questions out loud and Chris will provide the answers. We'll now turn the presentation over to Chris Hoyme. Chris, good morning.
Good morning, Sean, and thank you. Good morning, everybody. Again, my name's Chris Hoyme. Many of you I have worked with over the years in our great relationship with the SDRA. As most all of you know, I am admitted in a variety of states, including South Dakota, where we regularly practice. We have an office, West River in Rapid City, and again, believe our relationship with the SDRA has been very positive. We would continue to ask that you all take advantage of the retainer relationship and call me in my office on any HR related questions. My contact information is at the last page of today's presentation if you don't have it already. Today's presentation is going to be on a variety of topics that we're going to try to cover in close to an hour. These topics really came based on interest from you. In a previous email, we've asked many of you to identify topics you would like to hear, plus questions you had regarding various HR and employment topics. And I have tried to incorporate many of your questions and the answers to those questions into today's presentation. The response to those proactive questions and topics has been very positive and should be able to make today's presentation even more valuable. Today we're going to try to cover hiring, discipline, termination, wage and hour questions and answers, some developments we've seen with the new presidential administration as well. We will take some questions when we were done, in addition to the questions you previously submitted. So we do have our work cut out for us in the next hour. Before we start, though, and I was chatting with Sean before we started, interestingly, one of our South Dakota clients this morning was faced with a data breach email scam scenario. Without identifying the client, I will say it's a mid-sized South Dakota client who, through an email scam, accidentally produced Social Security numbers, dates of birth, and payroll information regarding a large number of its employees by accident due to this scam. So the SDRA may be sending out an alert to this effect, but wanted to give you all a real heads up that those type of emails soliciting confidential and personal information about your company and your employees are out there. And to bring it close to home, a South Dakota very reputable company was the victim of such a scam yesterday. So just giving you a heads up. Now let's turn to our first topic, which is smart hiring. And as most all of us know, the name of the game in terms of your most valuable resource, which is your employees, is to keep those employees, retain those employees, and make them loyal, valuable, and efficient over time. It costs 3 times as much, based on studies that I respect, to terminate the employment of an employee, hire a new employee, train that employee, and get them up to speed than it is to retain employees, work with them to remain efficient and become more efficient. So the name of the game is to make a good decision as we move forward in our hiring practices. The job description, which most all of you hopefully have, and it is accurate and updated and reviewed at least annually, is very important in the interview hiring process. I don't know if you all can see this cartoon, but we have Lucy and Snoopy. Snoopy, of course, is taking a break on top of his doghouse. Lucy says, "I've always wondered why you decided to be a dog." And Snoopy says, "I was fooled by the job description." Again, the job description is really kind of our roadmap and guide to making a good hiring decision and asking questions during the interview. We need to make sure that, again, it is accurate. It sets forth the essential duties of the job, the responsibilities of the job, the physical requirements, and addresses the work environment. Many job descriptions that I see do not have accurate physical requirements, for example. They may have physical requirements that are not regularly associated with that job, and therefore we have a job description that really isn't accurate or helpful in the hiring process. Now, in terms of hiring, we have to prepare for the interview. We need to make sure that we have a list of job-related questions that we've actually written down before the interview that focus on the experience, the skills and abilities required of the job, what we've seen with past performance in terms of what that job will require. Therefore, it is very helpful to have the interviewer or interviewers very familiar with the job. In many cases, if not most cases, we would have a supervisor who has an intimate knowledge of the job together with an HR person conducting the interview. Before the interview, we would want to make sure that we have reviewed the application and that we have only selected the applicants. We've pre-screened those in a very consistent, uniform manner that have the best experience qualifications that match the job requirements. You certainly are able to and legally protected by screening applications and only weaning out those that set forth the applicants with the most experience that relates to the job. Now, during the interview itself, make sure that we treat everyone the same. We ask the same questions. We describe the job expectations. And if we're not sure whether or not we should ask a question, and I'm going to get into the do's and don'ts in just a minute, if we have doubt about a question, don't ask it. Stick to the script. Now, make sure that we understand that as we gather information during an interview, there are many areas that we will discover, information that we will discover that is valuable, and it's legal. It's legally protected. If we have an applicant that shows frequent job changes or an erratic career path, likes to talk poorly about former employers or coworkers, reveals confidential information about an employer, has gaps in employment, negative information on background checks, and we'll address that, demanding or difficult at the pre-hire stage, seemingly, if you will, likes to kind of be in a confrontational manner. Those are all very legitimate areas to grade someone low and ultimately point to if you decide not to hire them. Gaps in employment jump out at me. An applicant during an interview who likes to say, at my prior job, they didn't know what they were doing. My supervisor never understood the job. Anybody who talks bad about a prior employer or supervisor or coworker usually is not someone you're going to want working for you, because they will also talk bad about you and your company and have probably a negative outlook on their employment. Certainly that's legally protectable if you decide not to hire them for that reason. During the interview, make sure we take notes. Make sure those notes obviously only set forth legally protected areas, but those notes would reflect consistency, uniformity, and reflect an applicant's experience and the answers to the legally protected criteria that we just discussed. Excuse me. Now, during the interview, we want to make sure we understand some of the don'ts, which is, in general, don't make promises you can't keep, like, as long as you do a good job here, you'll get promoted. Don't oversell the job. Don't talk about how great it is or how much they're going to get paid, or present too rosy of a picture if it isn't realistic. Don't compromise. If you have a pool of applicants and none of them meet your minimum criteria, keep looking. Don't make a hiring decision from that pool. Things you can and cannot ask, and I think all of us have a pretty good idea of this, obviously, because these are protected areas. Protected areas include race, religion, sex, disability, union affiliation, things like that. We're not going to ask, even in small talk, attempting to make the applicant comfortable. We're not going to ask what church they attend, what affiliation. We're not going to say, oh, what sect do you belong to in whatever religion? Do you belong to an ELCA Lutheran Church, for example? We're not going to ask how many children they have. We're not going to ask about how they are going to get their kids to daycare. We're not going to ask about maiden name. We're not going to ask about, oh, are you pregnant again? Things that we would ask females, but we would not ask males, and that could be evidence of gender discrimination. Likewise, we're not going to ask, are you able to work long hours and not have the ability to take care of your children? We're not going to talk about marital status. We're not going to talk about your favorite Chinese restaurants. We're not going to say, oh, you don't have any kids, when do you expect them? All of those can serve as the basis for gender discrimination or national origin discrimination. We're not going to say things like, what kind of name is that? Is that Armenian? Is that a Jewish name, for example? All of those are signs of potential discriminatory questions. Many times those type of questions are asked when we're trying to be humorous, we're trying to make the applicant feel at ease, and they would fall under the small talk category. Regardless of what your intent is, if you ask a question that could be easily construed as sexist, racist, ageist, etc., it could provide evidence in a discrimination allegation if the applicant is not hired and decides to pursue a discrimination claim saying, oh, I didn't get hired because of my age, my race, my sex, whatever it is. Likewise, when we talk about our company, we want to make sure, or the job, we want to make sure that we're not saying things like, oh, we're a young, dynamic company. We're looking for fresh, energetic people. This job requires a lot of stamina. Are you up to that stamina level? All of those could form the basis for an age claim because they would show over concern about the applicant's ability to perform the job in a way that a younger person could. Okay? Likewise, and now we're in the don'ts, we're still in the don'ts, How do you spend your spare time? Can you read and write a certain second language if the job doesn't absolutely require a certain language? We don't talk about union affiliation. We don't talk about what graduation class you were in. We don't make a disparaging joke, for example, that could be misconstrued. We don't tell an elderly applicant that they are overqualified. Overqualified can mean code words for age discrimination. What can we ask? We can ask about an applicant's responses on their resume. For example, why did you leave your former employment? Why do you have gaps of employment? What kind of references do you believe you would receive from former employers? What were your prior job duties? What job duties are you interested in? What did you like your last job? What did you dislike about your last job? We can give them hypotheticals as long as we give them to all of our applicants. How would you handle a situation like this? When faced with a situation like this, how did you resolve it? As long as our questions are consistent across the board, we're asking all applicants similar questions, we're going to be in good shape. Likewise, many of us may use social media in our hiring process, and we need to be real careful that although we can find interesting information that might be valuable on social media, we can also find information that may be protected. For example, an applicant in a wheelchair, an applicant talking about the drug rehab they went through, which might be protected by the ADA, an applicant talking about on social media the number of workers' compensation claims they've had. That may be protected under workers' comp retaliation laws. So if you are going to use social media gathering as part of your interview process, we would advise that that information be gathered and screened by someone who is not making the decision on the hiring process, and that the information that is not protected is provided to the decision maker. Otherwise, we could run the risk of a discrimination claim based on protected information taken from social media. Now, let's say we go through the interview process. Are there legitimate reasons that we could have to reject an applicant? Absolutely. They can't work the scheduled hours. They don't have experience with the amount of work we have. They can't explain gaps of employment. They don't have sufficient qualifications in certain areas. They don't have sufficient education in certain areas that are required by the job. We were unable to confirm employment history. The skill set they had with specifics was not as good as the candidate we selected. Those are all legitimate reasons we can rely on. Make sure that when we make our notes that would reflect why we did not hire a certain applicant, that we are detailed. We don't use generalities such as not the best qualified, didn't have a good personality, didn't present well. We give detailed explanation. We say lacked experience in whatever they lacked experience in, was rude during the interview, didn't make eye contact when asked about X, Y, and Z, has no prior experience in whatever it is, mechanical employment background, whatever it is, where we're using specifics. If you're ever faced with a discrimination claim, whether it's hiring or any other type of discrimination claim, detail usually carries the day, and generalities are a negative. So the more detailed you can be that identify the reason why an applicant wasn't hired in your notes, the better and less risky your hiring decision will be. Bottom line is, if you hire based on job qualifications and document the reason why you did not hire that person, you will reduce your risk substantially. Now, we did have some pre-webinar questions submitted. And I'm going to run through those. Some we've covered, some I want to specifically address. For example, one question was, what specifically can you not ask on an application? I will tell you that right now, in the United States, we have a split of authority on what can and cannot be asked in an application in regard to a felony conviction. I will tell you that in South Dakota, we are allowed to ask about a felony conviction, and we can rely on a felony conviction as a reason not to hire. Now, the EEOC believes that more information than simply a one strike and you're out on a felony conviction is necessary. However, South Dakota right now is simply treating that as guidance, and it's not the bottom line requirement. But I could see ultimately an evolution of the law where we would have to have more of an explanation not to hire someone than simply a felony conviction. I will also tell you, for you multi-state or multi-location employers, as you know, there are many cities and states that do not allow a simple felony conviction to strike out or prohibit an applicant from moving forward during the interview process. But generally, for private employers in South Dakota, you are okay. Next question, what questions cannot be asked during the interview? I think I've addressed a number of those, but the bottom line is a question that could be construed of as protected, such as race, age, religion, sex, disability, and the like. A question associated with any of those protected topics should not be asked during an interview. Next question, background checks. Can they be used? How thorough can they be? You absolutely have the right to perform background checks on your applicants, provided, if you're gathering information related to credit or court history and the like, that you get a release from your applicant. And there are forms for this, and if any of you would like us to provide you some examples, simply email me. But you have to get a release, and you have to, in many cases, comply with the Fair Credit Reporting Act in terms of your obligations to report back to the applicant if they are struck down by certain adverse information during the interview process. So you can use them, but there are rules, and you must comply with those rules in a variety of areas. And for further information, just reach out to me and I'll provide you more detail. Should a company do a criminal background check for all candidates? The answer is that's up to you. It can be somewhat expensive, although the price is coming down. And in a state such as South Dakota or Nebraska or North Dakota, for example, where the unemployment rate is very low, many times because of the shallow labor pool, employers just can't find enough qualified candidates who might be knocked out by a semi-marginal background check. So that's an evaluation you'll have to make. I've had a number of well-intentioned clients who said, absolutely, I want to do a background check, and if X, Y, or Z shows up on the background check, I'm not going to hire them. At the end of the day, they weren't able to hire enough people, and they revised their outlook on how aggressively they wanted to use background checks. Can we use pre-employment drug tests? The answer is yes. South Dakota is not as rigid in terms of what is required for drug testing protocol and process than many of its neighboring states, such as Iowa and South Dakota, but there are definite rules that need to be complied with on pre-employment drug screening or even post-employment drug screening, and I will be happy to provide you with information regarding the requirements there for all employers if you simply email me, and I can show you what's required. But the bottom line is, absolutely, you can use drug testing as part of your pre-employment process. A final question in regard to hiring, the hiring process. It says, what am I allowed to say if someone calls me for references regarding a former employee? And the answer is, absent a release where the employee has said, I'm going to hold harmless any previous employer in regard to the information they give, absent a release, I think you have to be very guarded in terms of simply saying, yes, the person worked here, here's their dates of employment, and really not providing information beyond that, such as, were they terminated, would you rehire them again, and the like, unless in the very rare exception, let's say they were convicted of, in a court of law, theft, they were convicted of sexual assault related to the work environment, then you may have an obligation to share it. But absent something as extreme and unlikely as a criminal conviction that the employer is aware of and associated with the work environment, the information provided absent a release should be very limited. Okay, our next topic is proactive performance. And again, some of this is fairly general and things you do, but I did want to provide the information to you. I know the SDRA will provide this PowerPoint to you to have for your review if you would simply request it from them after this webinar. But remember, what we're trying to do with performance related discipline, performance reviews, and the like is to train people the right way. If they make mistakes, to identify those mistakes, give them an opportunity to correct them and become better employees. And if all that fails, and sometimes it does, but generally we're able to correct performance problems, but if ultimately it fails, we have documented our efforts in a way that reduce risk if we have to terminate that employee, heaven forbid. Now, what are some major performance errors that I see regularly with South Dakota employers, like many of my Midwest employers, and that is failure to act. Many supervisors and employers don't like confrontation, therefore they ignore problems until they become too big. Therefore they ignore it, they don't act promptly. It's kind of like the parent who says everything's great with their kids, everybody's happy, and then one day they simply fly off the handle and say, look at what you've been doing for the last month. You haven't cleaned your room, you haven't washed the car, whatever it may be. It's driving me crazy, you're grounded, and the child has no idea that they have been doing anything wrong because the problem has been ignored until the parent simply snaps. The employer here is the parent, and unless we address performance problems, we cannot expect they will be corrected. Sometimes our avoidance methods are interesting. We simply transfer them to another supervisor. We simply don't like the confrontation. We don't like a problem employee. They're not doing a good job. Therefore, we change duties. We just hope they quit. We reduce their hours, put our heads in the sand and hope they just go away. We postpone disciplinary actions. We ignore. We minimize performance issues because we don't want to sit down and have that difficult conversation with them. Maybe it's because we see them socially, we see them at church, whatever it may be, but we don't have the necessary conversation. We demote them without telling them why and the like, and we have a problem. The next primary performance error we see is inconsistency. This happens and it is a breeding ground for discrimination claims. And the example I can give you is, let's say we're running a two-shift operation. Let's say that on first shift we have an attendance policy that is uniformly and properly applied. And in my hypothetical, let's say it led to 2 female employees violating the policy, too many tardies, too many unexcused absences, and they were terminated properly under that policy. Unfortunately, in my hypothetical, we have male employees working on second shift subject to the same policy, only they have a lax supervisor who doesn't hold them to the policy. They accumulated more tardies and absences than their male counterparts on first shift. They don't get terminated. The female terminated employees say, I think I've been discriminated against because even though I violated the policy and got fired, and I admit I violated the policy, males on second shift, subject to the same policy, didn't get fired. Therefore, I think males are treated favorably to females, and I think I was discriminated against. Was the intent ever to discriminate against females in that hypothetical? No. But what's the bottom line? We're letting females go. We're terminating their employment, applying the same policy that we're allowing male employees under the same company umbrella, although on another shift, and therefore clearly that would be a claim that could have some real risk in terms of discrimination. So when we're managing performance, we need to make sure we're consistent, we're enforcing expectations evenly, and we are enforcing them uniformly across shift levels, supervisor levels, if you have multi-location levels as well. And that requires either upper-level management or HR to ensure that all discipline is evenly distributed across all those different levels I just described. Okay? The third major problem is failure to document. I'm sure all of you have sat through documentation presentations forever, and I understand that, but we know that the best evidence in any type of discrimination case or wrongful discharge case is always what is written down. We know that in terms of what a jury looks for is what is fair. Was the employee treated fair? Were they given a warning? Were they told what they were doing wrong? Were they given a roadmap on how to correct it? And were they allowed adequate time to correct it? If all that is done through proper documentation, you will always reduce risk to the point of not having any significant risk. And more importantly, you'll probably be changing that employee's performance because they've been told what they're doing wrong, given a roadmap on how to correct it, and giving time to do it. Now, good documentation. Here's a nice checklist, and again, we'll provide these materials to you, but if you hit these checklists in terms of what a good piece of performance-related documentation should possess, you're going to be way ahead of the game. And basically, for those of you of my vintage, it's kind of the Joe Friday, remember Joe Friday from the TV show, Dragnet? Just the facts, ma'am, who, what, when, where, and why. That's what we need in terms of written discipline, accurate and verifiable, okay? All of that, if done properly, will demonstrate that the employee was treated fairly. For example, if we have written documentation that says Tom fails to pay attention to his work, as opposed to Tom gave the wrong patient chart to the doctor on March 2nd, obviously the bottom one is more detailed. It's going to reduce risk, and it's also going to give Tom a better chance to see the error of his ways, correct his performance, and become a better employee. The same is true with the second example. We don't say Sally's always late. We say, hey, Sally was late on these specific dates. It reduces ambiguity, decreases risk, and Sally is clear that she has missed 1, 2, 3, 4, 5 days. Okay. ABCs of discipline. I need simple things to remind me of the best way to do it. A, B, C, D, and E. Always be consistent. Document everything. Okay. The bottom line on this slide is, if heaven forbid you get into a jury situation, a trial, juries will always conclude that if we didn't put it in writing, it must not have been important. And we can put on witnesses till we're blue in the face to say, hey, on a daily basis, we counseled an employee about his or her performance problems, and she was treated fairly, or he was treated fairly, given adequate warning. We told them daily what the problem was. A jury's going to say, if we didn't put it in writing, therefore it either didn't happen or wasn't that important. And 9 times out of 10, the jury is going to believe that the employee was not treated fairly because the performance issues or the discipline was not put in writing. So that's the bottom line. What is effective documentation? Write English so that anyone who reads it, plain English even, anyone who reads it will understand why the company took the action that it did. Again, a nice checklist. Try to give you all checklists. So when you get these slides, you'll have it in front of you. Every piece of disciplinary documentation should be crystal clear that it describes the expectations and notification regarding the discipline, tells what the employee was doing wrong, gives the employee a very detailed understanding, sets a roadmap, an action plan to get it corrected, tells what the consequence will be if it is not corrected, i.e., you could face discipline up to and including discharge, gives a deadline for correction. And let me step out for a minute there. Many times I counsel with the employers who say, okay, Chris, we'll do the action plan, we'll put it in writing, we'll do all of this, but I've about had it with this employee. I want this performance corrected within 4 days. Now, obviously, 4 days is not a reasonable time for most performance-related issues. You have to give a reasonable time. I associate reasonable time to correct most discipline to be at least 30 days, and in many situations it may be 60 days. Now, can that be somewhat problematic for an employer who wants a difficult employee out the door? Perhaps, but in my experience, and I've only been doing this for about 30 years, in my experience, 7 out of 10 times, if we follow this roadmap in terms of effective documentation, 7 out of 10 times the employee will change their behavior and become a long-term loyal employee who is given a second chance to correct their performance, and you're way ahead of the game. Now, the 3 out of 10 times when it doesn't work out, at the very minimum, you have reduced risk of any subsequent lawsuit because you can show we didn't wrongfully terminate this individual. We didn't discriminate against them. We told them what they were doing wrong. We told them how to fix it. We told them what was going to happen if they didn't fix it, and we gave them enough time to do it. If you do that for a problem employee that ultimately you have to terminate, you are going to have reduced your litigation risk extremely low in terms of any subsequent lawsuit. Okay? So, heaven forbid, we do have to take action and terminate one of our employees who just didn't work out. And I will tell you that the termination process is the most high-risk litigation scenario employers face. And it's employers who have 2 employees all the way up to an employer who has 2,000 employees. Because if we make a mistake during this process, in essence, the horse is out of the barn. They are dismissed. They go see a lawyer. They go file a charge of discrimination with the South Dakota Department of Labor. Whatever it is they do, if we've made a mistake during this process, at that point, we are looking at significant opportunity for litigation. Why would an employee sue? If they don't believe they've been treated fairly, if they believe they've been treated dishonestly, if they suddenly don't have income and they can't pay their bills, they expect that perhaps a lawsuit would address all of these. Now, in many situations, an employee is probably dead wrong that they were wrongfully terminated. But if they believe they weren't treated fairly, they were treated dishonestly, they're broke, whatever it is, the chances of them pursuing a lawsuit significantly increases. All right, jurors, and I'm a trial attorney, so I regularly try cases. Jurors always ask, was this employee treated fairly? We have to be able to win the fairness issue by saying we gave this employee due process. Well, what is due process? It really is the checklist that we just went through. Were they given notice of the problem, an opportunity to correct it? Were they treated fairly if there was an investigation into wrongdoing and the like? Was there sufficient documentation and warning for them to correct their problem? And was the company consistent in applying their policies? So, before you make the decision to terminate, you need to ask yourself these questions before any employee is terminated. And this seems easy, but I'm always surprised. I would say shocked, but that sounds pretty dramatic. But I'm always surprised by how few times employers, whether they're small, medium, or large, don't go through this checklist to make sure they've reduced their risk and they're on firm footing. If every employer had a protocol that said no one gets fired until HR or upper level management takes a look and asks these questions, we would reduce our risk dramatically. Have you treated employees in similar situations consistently? Do they have any reason to claim discrimination? Any reasonable reason? Is there any type of contract? Are there any inconsistencies in terms of the personnel file? If we're getting ready to terminate an employee for performance and they have 3 years of average to good performance evaluations, then we do have some inconsistency. Because if I'm an employee and I'm 55 years old and I get terminated for poor performance and I know my last 5 years of performance reviews are average to good, I'm certainly thinking I may be on firm footing to file an age discrimination claim because the company never warned me, didn't treat me fairly, didn't give me due process, and therefore they must have fired me for an illegal reason, such as, in my hypothetical, age discrimination. Likewise, do we have any issues related to retaliation? Do we have someone who recently filed a workers' compensation claim getting terminated? Do we have someone who has raised an OSHA claim or a sexual harassment claim getting terminated? Now, does that mean we can't terminate them? No, but we better make sure that our proof is clear, our documentation is excellent, that supports our unrelated, legitimate reason for letting them go. But this is the checklist that needs to be followed. Always involve a higher chain of command. All of you need to have a process, without exception, that says nobody gets fired unless HR and or upper level management signs off on it. Have we reviewed our documentation? Have we reviewed our personnel file? Have we reviewed our reasons for termination? Are we crystal that there is no significant risk for discrimination and the like? Likewise with our termination meetings, and I can't tell you how often we have situations where the meetings are long, drawn out, there are arguments, and all I can say is a termination meeting should be extremely brief. It should simply be giving the news, we're going to let you go, we're going to go in a different direction, we wish you the best. It's not a discussion of the reasons. Please hand in your keys. We treat them with respect. We treat them civilly. We have a witness with us, but it is a meeting that is short and sweet. And there's a nice checklist in the materials there. Again, practical tips. We don't apologize for anything. This is a meeting that should take no more than 5 to 10 minutes max, and the employment relationship is over. We wish them well, and they are out the door, treated civilly, honestly, and carefully. Likewise, if we have a problematic employee, and I'm not advocating certainly a settlement agreement or a severance agreement for anyone, but if we have a situation that is high risk, we may want to consider paying a certain amount of money, whether it's 2 months salary or a year's salary, whatever it may be, depending on the risk, and in exchange for them receiving this money, they sign a release so they can't sue you. It's pretty simple. I deal with SDRA members all the time who may want to consider that option. All right. Now we're moving into wage and hour issues, and a lot of the wage and hour issues that we're going to talk about today really come directly from your questions. The questions we see, and if I had to gauge in terms of all of the calls and emails I get from SDRA members, and we get hundreds during the year, I would say 70% are related to wage and hour issues, such as child labor, independent contractor, vacation, wage differentials, as we can see the list. So please understand that if you are faced with a wage and hour issue, that we take advantage of the retainer agreement, we get some advice, because the liability for making a mistake on whether to pay late, whether to pay overtime, for example, violate child labor and the like, are significant. So in regard to some of these topics, for example, child labor, I would simply indicate to you that if you go to the South Dakota Department of Labor website, there is a list of what can and cannot be done for employees under the age of 18, under the age of 16, and under the age of 15 under South Dakota law. Then on the same page, the same web page of the South Dakota Department of Labor, there is a link to the federal law, which is more restrictive than the state law, which is true in many states, on what a employee under the age of 18 can and cannot do in terms of occupation, in terms of hours, in terms of days they can work. One question I got before this was, well, how do I balance between the South Dakota law that might be somewhat different than the federal law on child labor? And the answer is, the law is clear that you have to abide by the law that gives the most protection to the employee. So if the federal law in this case provides more protection on child labor issues, you have to follow that law. And therefore, you need to get online and look at it's called Youth Employment under the South Dakota Department of Labor, and then also go to the link. It's called USDOL website on the same page, very easy to follow, and it lays out what employees under the age of 18 are restricted from doing, hours of work, days of work, and the like. Now, if you aren't comfortable getting online or can't find it or whatever it is, I am happy to provide you that information because it's crystal clear. If you simply email me, I will send you all of the information set forth on all of those websites, including a Q&A for those child labor issues. So please take me up on that. We are seeing very significant issues in regard to independent contractor issues. If you have independent contractors that you pay through, you don't pay a regular W-2, you need to make sure that you comply with the law where the independent contractor sets their own hours of work, uses their own discretion, uses their own tools, and therefore you don't have to pay them as employees. You don't have to keep workers' compensation insurance for them. You're not responsible for them in discrimination, but they are very aggressive tests that define what an independent contractor is. And again, if you email me, I'd be happy to provide it. Likewise, in regard to vacation, in South Dakota right now for private employers, if someone has accrued vacation, unless you've expressly said you're going to pay accrued vacation in your handbook or made an oral comment to that effect, if an employee leaves your private employer place of business, you don't have to pay accrued vacation. In many bordering states, such as Nebraska and Iowa and Minnesota, you do. So remember that. That's an area where we get a number of questions. Likewise, we got a question saying, do I have to pay the same rate of pay for different jobs in my company if an employee does two different jobs? Let's say for 20 hours a week they do one job and for 20 hours a week they do another? And the answer is no. You can pay them different rates of pay for different jobs, provided you pay them at least minimum wage, which, as we know, in South Dakota right now is $8.65. Now, another question dealt with wage deduction for damage, theft, and supplies. South Dakota, which is a fairly employer-friendly state for private employers, does allow deduction for theft, damages, uniforms, and the like, but it's always best to have those deduction reasons, if you will, set forth in writing that says, if we pay for your uniform, that allows us to deduct X, Y, and Z from your paycheck. If you damage the company, we are allowed to deduct even below minimum wage. I like it in writing. And before you get in a situation, and usually it happens with employees who voluntarily quit or are fired, and we're asked what we can deduct from their final paycheck, get some advice through your retainer opportunity with this office to make sure that you are not violating the law. But South Dakota is employer friendly. It will allow deductions below minimum wage, provided generally that the employee was given notice and the employer was upfront about the opportunity that could happen. Likewise, I get a number of questions on the clock time. If we have employees that are doing anything related to their job, which includes generally booting up their computer, putting on safety equipment, sweeping the floor, whatever it may be, where it really is related to their job, either pre or post shift, generally those type of activities are covered. Obviously, driving to work, as long as you're not asked to drive to another work site, but you're driving to your regular place of employment, that is not covered. But if I come in the door and before I can start my job, I need to boot up my computer, I need to do a bunch of paperwork, I need to do X, Y, and Z before I actually log on, generally things like that are covered. Likewise, we get a lot of questions on authorized overtime. We hear this regularly where an employer will say, hey, unless I consent to pay you overtime, I'm not going to pay any. And the Department of Labor is clear that if you have an employee who disregards either your individual directive or your policy directive that they're not to perform any overtime without consent, and they do anyway, you still have to pay them because they provided work to you even though you didn't want it, but you still have to pay them, but they can face discipline for violating your directive or your policy. So never indicate to someone, well, we told you you weren't supposed to work overtime, you did anyway, we're not going to pay you. You have to pay them. Always err on the side of paying, but remember they can face discipline. Likewise, in regard to record keeping, a number of questions that you all presented were, how long do I have to keep payroll records? How long do I have to keep personnel records? How long do I have to keep workers' comp records? How long do I have to keep OSHA records? The answer, of course, differs with each type of record. I will tell you, if you want to be super safe, keep everything for 6 years, which again, easy to say, hard to do. Or if you would like a much more specific table in regard to all of these different type of records, simply email me. I'll send you this table that is already finished and you can see. But if you're simply erring on the side of safety, reducing your risk, remember, keep everything for at least 6 years. Another question was, can I keep things electronically? And the answer is yes, provided you secure them. You don't allow access to records, just like you wouldn't written records, to anyone who's not authorized to review them, that we segregate medical records and secure them as well. But you are allowed to keep written records as opposed to hard copies, okay? Tips, again, for those of you that wrestle with paying employees who are service-related, waiters, waitresses, and the like, We do have the opportunity to pay less than minimum wage. We can pay as less as half as minimum wage, provided their tips bring them up to that $8.65 minimum wage. We also allow tip pools, and we have some very specific questions, summaries regarding tips, tip pools, and the like that we would be happy to provide to you if you simply request them. Okay? Now, remember as well, we had a couple of questions on workers' compensation insurance. In South Dakota, if you have one or more employees, which means everyone, you have an obligation to keep workers' comp insurance, and if you don't, you're not protected by insurance, and you will lose the protection, which is significant, of the workers' compensation courts, which don't allow negligence claims in most cases, which simply very much restrict the amount of liability an employer can face if it has an employee that has a work-related injury. So make sure if you have an employee, one or more, that you have workers' compensation insurance. Another question dealt with FMLA, and the question really is, how many employees are required before the Family Medical Leave Act is triggered, and that is, of course, 50. But remember this, there's a caveat. If an employer that is smaller than 50 volunteers to comply with the FMLA and says we'll give leave based on serious health condition and the like, you are obligated to provide it. So well-intentioned small employers who may have language that obligates them under the FMLA simply wasn't clear on drafting their handbook or their policy. If you reference that, you are responsible for it. Okay? Finally, had a couple of questions regarding dress code. General questions like, can we have a dress code, and can we enforce a dress code? And the answer, of course, is yes. The dress code can't be discriminatory in terms of gender or religion and the like, but I will tell you the law is clear that if we have employees that are dealing with the public, i.e. sales, i.e. receptionists, i.e. waiting on people, serving food, selling clothes, whatever it may be, selling cars, that certainly you have the right to uniformly require your employees who interact with the public on a regular basis to meet a reasonable dress code. And I've had situations where retailers have salespeople who are wearing a lot of jewelry in their ears, in their nose, in various other places on their body. And obviously, if you're interacting with the public, employers are given much more leeway and discretion in regard to applying a reasonable dress code. So don't be paralyzed by concerns about discrimination or harassment, provided your dress code identifies those employees who deal with the public and is reasonable in nature. And certainly somebody requiring such an employee to look good, represent the company in a quality way is legally supportable. Now, the last topic is interesting, but I think most of us are up to speed on what we expect from the Trump administration, in that we have a general expectation that they will be employer-friendly, more employer-friendly than we saw before. There's a caveat there, though, and it's really twofold. One, the transition of power between the Obama administration and the Trump administration in terms of getting people confirmed and transitioning the laws is going to be a very lengthy process. I don't think we're going to see significant changes in employment laws for at least a year and probably two. So we're still, in essence, abiding by the Obama employee-friendly employer laws on such as background checks, systemic discrimination and the like. Also, the second caveat is many of the people that he has appointed so far, such as the acting head of the EEOC, is not quite as employer friendly as was expected. And therefore, we really have to keep our eyes and ears on, for example, what the EEOC is going to do in regard to LGBT issues, systemic discrimination, background checks. For example, many of us thought that the EEOC budget would be drastically reduced in terms of enforcement. On what we've seen so far is they have not cut the EEOC budget. They have cut the DOL budget. But again, this is kind of an anomaly, a kind of an exception as to what we expected. So don't fall into the trap of expecting as of January 20th that suddenly all of our employment laws were going to become more employer friendly, because we aren't seeing that, and we may see a gradual transition there, but it is going to take time. There are some specifics like the EEO1 data reporting change that was going to occur in 2018 that was going to be very burdensome to employers in terms of reporting compensation information. That has been delayed and in all likelihood is not going to occur. We're going to see a much less aggressive NLRB than we've seen in applying the National Labor Relations Act to non-union employers like you in South Dakota. We are seeing a quicker transition to that in a variety of areas. So I don't think we're going to have near the risk of violating the National Labor Relations Act once this transitions in the next year or so than we had under the Obama administration. The DOL, the bottom line DOL issue we're seeing, of course, is the overtime issue. I know I gave a webinar to all of you and also presented live to many of you saying that the overtime rule was going to change, that the threshold for compensation in terms of what exempt employees had to be paid was going to double. As we know, that law was enjoined by the Fifth Circuit Court of Appeals. Surprising to all of us, even those of us employers that had already implemented the change or were getting ready to implement the change. Right now, that law is simply delayed. It is enjoined. The new Department of Labor nominee, who I believe will be confirmed by tomorrow, Acosta, he has indicated that he is going to roll it back to some degree, but for those of us that expect the new overtime law will simply be canceled, will simply not occur in any form, I think we're going to be surprised. I think we're going to see some change in the floor level of the minimum compensation, some type of increase. I don't think it's going to be the double increase we saw with the original overtime rule, but I think we're going to see something. But again, we're not going to see that, I don't think, for at least 6 months and probably longer. But this is definitely a wait and see issue. We're also going to see a much more aggressive use like we had with the Bush administration, where employers will collaborate with the DOL as opposed to an adversarial relationship, in the use of the opinion letters where employers can say, hey, I'm not sure how this is going to work. Write the DOL will send an opinion letter giving their opinion on how this law would apply to them. Again, I don't think many of you are watching this fiduciary rule in regard to wealth administrators. That has been indefinitely delayed. We've all seen with Obamacare and the ACA that an attempt to repeal and replace has failed. We are continuing to monitor current efforts to revise the law. We're all watching it closely, as I'm sure you have, and we will, along with the SDRA, get you directives as soon as substantive changes, if they do occur. Because right now, Obamacare is simply not changed, and the status quo exists. We're supposed to see federal tax reform for corporations. We're hearing even a 15% tax rate. Again, a wait and see. We're monitoring it closely. It really is a liquid situation. We're seeing significant enforcement of our immigration laws. We're seeing an H-1B visa program that has been greatly reduced and monitored, as I'm sure those of you that use H-1Bs have seen. We need to watch that closely. E-Verify, the prediction is in the next year or two that all employers may be subject to E-Verify. We're watching that closely. In regard to DACA, that is the Deferred Action for Childhood Arrivals who were born here to illegal immigrants. We are not seeing immigration in terms of deportation enforced in regard to the DACA program. We're watching that closely. But what we are seeing through the DOJ and Jeff Sessions, the Attorney General, is very aggressive enforcement of current immigration laws in terms of both employers and in various municipalities, simply enforcing the law on the books. Finally, we did have Justice Gorsuch nominated. It was a fairly bloody process, but he was confirmed, and we expect that he will bring the court more conservative than it has been with the 4-4 split since the death of Justice Scalia. Although I think it's safe to say that Justice Gorsuch will not be just a conservative automatic on many issues. He's a very thoughtful judge, but we do anticipate a little more employer-friendly decisions from Judge Gorsuch than what we've seen with the simple 4-4 version of the court since Judge Scalia's death. And finally, President Trump did say that he favors some type of paid maternity leave, that we think we'll see this out of the Congress in the next year or so. We also think, very interestingly, that although on a federal level we may see more employer-friendly laws and transition to those laws, we think on a state and local level, we don't think we'll see it in South Dakota, but for those of you that are multi-location employers across state lines, we need to pay real attention to what states and localities are doing in regard to their own minimum wage and overtime laws, paid sick leave, LGBT, criminal background, because even though the federal law may be more employer-friendly, the state law may actually give more rights to employees, and in many cases may have to be followed for those of us that have locations in those other states and localities. Again, sorry to run over a little bit. We thank you for your time. My email address and telephone number for those of you that want information that we talked about today, please request it. And for those of you that have used the retainer, a reminder of my contact information. For those of you that haven't used the retainer, use it. Give me a call, send me an email on your HR issues, and we will address your question ASAP. So again, thanks for your time. I think we may have time for some questions that Sean will reference, and we'll do our best to answer them. Appreciate it.
Thanks, Chris. Again, we'll remind everyone that if you have a question, you can go to that webinar panel on the side of your screen, and you should see the questions box. Just type in your question and then click on send. We'll go ahead and go through, Chris, some of those questions that we've gotten, and it's a great presentation as always, and we appreciate your thoroughness in answering a lot of our members' questions. First one that I've got out of the block, Chris, is there any way to learn about employees' nature when assessing cultural fit without being able to ask, what do you do in your spare time? In the past, we have left it fairly open by saying, tell us about yourself. This tends to bring out hobbies as well as work habits.
Yeah, I think it's an excellent question, and not to lawyer everybody, but you know, there's two sides of the coin here. One, a question like that that's open-ended can provide very valuable information in terms of hobbies. You know, they like to volunteer, they're very mechanical, whatever it may be. But it could also, you know, run the risk of providing some protected information that we couldn't rely on in making our decision. So from a practical common sense perspective, I don't have a problem with the question. If someone were to volunteer something that you knew was inappropriate or protected, just don't reflect it in your notes. And if there is information in the question that you can rely on, like shows it likes to repair, lawnmowers or small engines, and you're hiring for a mechanical position, I would note that could be valuable. So, let's not throw our common sense out the window and be paralyzed by risk. I understand, we don't want to step in it, but those type of questions, I think as long as we use our discretion and our notes reflect the unprotected information, I think we're good, and I would still encourage those.
Chris, the next question is, say there was a discrimination issue and the employee was wrongly terminated and 2 years has gone by. Can they still sue their specific employer? Is there a specific time frame?
Yeah, it's a really good question. And generally for discrimination claims, once 300 days has elapsed between the event, in this case the termination, and they're filing a charge of discrimination with either the EEOC or the South Dakota Department of Labor, they would be out of time. Now, the caveat is that those time periods can be longer for certain other types of lawsuits, such as workers' comp retaliation would be at least 2 years. If they were suing under a contract, it could be 5 years. You can sue for race discrimination in kind of an anomaly under a very old statute. You can wait up until 5 years. So your garden variety discrimination claims or harassment claims generally would be limited to 300 days, but there are derivatives. Like, let's say someone said they were subjected in a harassment case to emotional distress. That time frame can be as long as 3 years. So I'm trying to give you both generally it's 300 days on garden variety discrimination, but there are derivatives that can be much longer.
If in a work comp situation, do we have to pay hourly pay for the doctor visit, for example, if they are still on the clock?
Yeah, generally if it is during work hours, you have to pay them whatever their workers' comp benefit may be if they are not working, and if they are working, then sure, whatever their wage is. You do have the right, if possible, to see if they can schedule their doctor's visits not during working hours, but for somebody who's working 8 to 5 during a 40-hour work week, of course, that can be very difficult. I also would say coordinate doctor visits and what you pay them with your workers' comp insurer on the front end. Make sure you do that. You should have an adjuster assigned to every workers' comp claim and rely on them to direct you as well.
Travel pay question here, Chris. In a job where employees customarily and regularly travel, however, are driving a company vehicle that hauls tools, is travel pay compensable from the drive to the job site if the tools are already loaded on the vehicle for them and they were merely meeting at the shop to drive to the job site? Is that compensable time? If the trip home is voluntary and they opt to come home hauling the tools, is that time compensable?
Generally, and again, I would advise maybe some specific consultation with me under the retainer because there's derivatives of all this, but generally the trip from home to the job site where they would meet up and get in the van or the truck generally would not be compensable if that's where they were originally assigned to work. But their drive from the home base to the job site and back at the end of the shift to the job site would be compensable. So generally, as I've described it, that would be the rule. Now, there are derivatives if they're asked to go from home to the job site as opposed to home to the home base where that would be compensable. But that would be my general answer, and I would encourage some direct conversation to make sure we're covering all our bases on any variables there.
And again, I'd remind our listeners to go ahead and send us your questions. Next one, Chris, what about rounding employees' time?
Yeah, it's a good question, and the general rule is it has to be uniform. If, for example, somebody who supposed to start work at 3 and they show up at 5 to 3 and we don't give them credit for that, if they would work 5 minutes after 3, we would want to make sure we're uniform in our rounding application so it's fair on both ends. Let's say somebody works from 3 until 11 and they don't clock out till 11:05. Well, you want to make sure you give them credit for the 5 minutes after because you didn't give them credit for the 5 minutes before. And again, you get a lot of variables with rounding practices, so I would encourage a call to make sure we're covering all of our bases there. But the bottom line is it has to be equitable on both sides of the clock.
Is FMLA based on the number of employees or FTEs?
It's based on the number of employees, but you can add up part-time employees to equal the minimum threshold number. Also, there are some calculations to use if you have a number of employees within a certain radius that equal 50. Again, without trying to not fully answer the question, because of the variables, I would encourage a direct call under the retainer so we can make sure that we're counting properly. But usually we're counting both full-time and part-time employees.
What are the guidelines for paying hourly versus salary?
Yeah, the guidelines are you have to pay hourly and therefore pay time and a half for overtime, which is over 40 hours in a week, to any employee unless they qualify under exempt classification under the Department of Labor exemptions, whether that means administrative exemption, executive exemption, sales exemption, whatever it is. Now, those rules as to what is necessary to qualify someone as exempt, and we like to qualify people as exempt if we can, because then we don't have to pay overtime, we simply pay a salary, but we've got to make sure they're able to meet all of those criteria in each definition that's set forth in the Department of Labor website. So unless and until they qualify, we pay them hourly. And if someone has a question after going to the website and looking at all the definitions for each different exempt classification, please give me a call and we can walk through it together. But err on the side of paying people hourly until you're very certain that they meet the definitional standards set forth under the exempt classifications identified on the DOL website.
And Chris, do you find that to be a fairly common occurrence for businesses as they sometimes misclassify those employees?
Yes, and it's a great question. The answer is yes, yes, yes. It's probably one of the most common high-risk mistakes that small and medium-sized employers make, where they pay someone a salary and they should have been paid hourly. What inevitably happens is someone leaves employment or gets fired, and they say, hey, they paid me a salary, and actually I worked all this overtime. They didn't pay me my time and a half for the last 2 years, even look back 3 years. In certain situations, the Department of Labor, either state or federal, investigates and says, you're right, you should have been paid hourly, you should have been paid overtime. And unless we have records that would indicate the person didn't work the overtime they are claiming, which we probably don't because we misclassified them as exempt and didn't watch their hours, we can run into real liability. So examining the classification, the exempt classification for your employees on at least an annual basis to make sure they fit in those buckets defined on the DOL website is something that every employer should do.
Chris, can you talk a little bit about the changes to the rules for the J1 summer employees?
I cannot, but if they email me or call me, I will get them those specific rules turned around.
Is there a minimum number of hours that must be worked before an employee is eligible for unemployment benefits in South Dakota?
It really depends on the job. It depends on whether or not the individual was classified as full-time or part-time. It's a pretty, there's a lot of discretion involved with the South Dakota Department of Labor. And again, if some specific follow-up is necessary there, just call me directly at my contact information.
And I think, Chris, that might be the last of our questions. Are there any last thoughts that you have before we wrap things up?
No, other than because all of these laws have so many variables, there really are not cookie cutter black and white questions and answers. And I'm sure you would join me in this. Your membership hopefully will take advantage of the retainer relationship, get further guidance, because it's always better to be proactive than run the risk of a lawsuit or litigation because we didn't comply with the law. And the SDRA just gives us great opportunity to get that proactive advice without cost for your membership.
Yeah, and I would reiterate that comment as well, Chris. This has been a great partnership that we've had with Jackson Lewis. I think getting close to probably 10 years now, Chris. I always kind of lose track of the time, but it's certainly been a great partnership. And the other thing I would mention for our members is, as always, we plan to schedule our fall tour around the state where Chris will be out for a longer format of this presentation and many other topics that are emerging on employment-related issues. And we would encourage you to consider attending those seminars when they're scheduled, I think, in September or October.
Sounds great.
With that, thank you, Chris, for a fantastic presentation. Again, we really do appreciate it. This webinar was recorded, and a link to the recording will be emailed to all of you late this afternoon. SDRA has several other webinars coming up, including a labor market data webinar on May 17th. Please visit our website at www.sdra.org for details. Again, we want to thank everyone for participating in today's program and for your support of the association. We hope you have a great day.